I should say before I get started, a student asked if there is a midterm exam, and there is none. But you can predict your grade just right here. Here's the points at midterm. It's just to add up quizzes and projects due by then, and there's the final. So you can predict your midterm grade, and you can predict your final grade. So I think I have to turn those in like 1 or 2 weeks. So I'll add up the total at some point in the next week or two and make a midterm grade out of it. The midterm grade has no effect on you. It doesn't appear on your transcript. It's just to guide you so you know how you're doing. Although some people tell me it has some effect on their financial aid or something. So some people it matters more than others. But most students, it doesn't matter at all. It's just to guide you. The only thing that matters is your final grade. And the other thing I want to mention is special events. There's one coming up tomorrow. This person will be a guest, and they have a hands-on project with Burp and Collie, which is apparently also going to involve hacking some kind of AI. So that should be pretty interesting, and it's worth extra credit for anyone who wants to attend. There will be food here for people who want to come in person, but people can also connect on Twitch if they want to, if they don't want to bother coming here in person. This is from WISIS, Women in Cybersecurity. So this is Tessa running that. She's very active, getting a lot of guest speakers and a lot of events, so that's good. Anyway, that's what's going to happen tomorrow night. And the only other, there's a free open source con. You can get a free virtual pass if you want to connect to that. And then there's lockpicking on October 29, which you have to be here physically for. That's worth extra credit in any of my classes if you want to do it. All right, anyway, so let's get to the module, which is module 7, I think. Yep, module 7. So I should be able to get it here. There we go, module 7. All right. So we're going to summarize in a very simple way the American legal system. Obviously, it's a huge topic, and I'm not a lawyer, so I don't know more than sort of what you get from watching TV about it. But here's the facts that are relevant to a forensic examiner. So there are state and federal laws, and you have a jury, which is a group of people to hear things. Not everything is a jury trial, but they typically are a jury trial. The plaintiff is the person complaining about something, saying that they have been injured in some way, and the defendant is the person that defends themselves. And so that's the common law is based on case law and precedent. Precedent is previous court decisions, and almost everything involving technology is really based on precedent because the laws are very unclear and they're old, and it's not clear how they apply to technology. So questions like can a cop just seize your laptop and look at it without a court order if you're crossing a state line or something, these are all pretty much based on precedent of previous decisions made. And that's why I watch the cases happen a lot. So civil law is the most common. That's where people are just arguing about money. Nobody is going to go to prison. Just you're arguing about money. You didn't pay for something. Your landlord didn't fix your house. You bought a product and it was defective, that kind of thing. So there's 3 primary bodies of law. Constitutional and federal law is in the Constitution. Those are federal crimes. Statutory law is written law at the national, state, or local level. And then there's regulatory law, which is regulations passed by agencies like DMV has rules about your car and your license and registration, and the EPA has rules about pollution and stuff. And this is what Trump and the Project 2025 wants to completely end regulatory law. And there is a recent Supreme Court decision that has gone a long way to end regulatory law and make it legal to pollute without any restrictions. The current Federal Society judges on the bench have determined that if you're like the EPA, you're not allowed to make decisions about what pollution goes out there. Instead, you should have a congressional decision for every time you want to outlaw a pollutant. And since Congress does nothing these days, that means you basically can't do anything. And that's the current situation pretty much, although these things are being battled in court. But that has made it all the way to the Supreme Court, so we can expect a lot of regulations to be ignored from now on, and that's already happening. People that have had to pay fines and stop doing bad things because of regulations from agencies like the Consumer Financial Protection Bureau and so on, are now refusing to do that and going to court expecting to win based on recent Supreme Court decisions. And of course, the right-wing attitude of this, I used to agree in the country, is that the people in Washington pass all these stupid rules and it's annoying and they're just wasting all our time and they should just shut up and let us do what we want. And that seems to be the direction the country's moving right now. Anyway, so you got a lot of courts, and the point is you can appeal things. We've seen it happen. So you can have a decision made at a lower case like a tax court, and you can appeal it. It'll go up through local courts of appeals and ultimately to the Supreme Court, the highest place you can appeal it. And as we are seeing in real time, if you are Donald Trump and you can afford to pay a lot of lawyers, a lot of money, you can drag things out for years. with appeal after appeal, argument after argument, perhaps forever. And that was Roy Cohn was his original attorney to do that, who was also the attorney that worked for Joseph McCarthy, the famous right-wing conspiracy theorist at his time, who was a model for Donald Trump, and before him it was Huey Long. This is called the paranoid style of American politics, and it's a successful thing. Every generation has these people who pick somebody like immigrants and blame everything on them and convince everybody that there are these scary immigrants everywhere. For Joseph McCarthy, it was communists everywhere. And you convince people that there's these scary people everywhere and you need me to protect you from them, and therefore I should eliminate all your rights and privacy and everything because I'm saving you from those scary bad people. And that's called the paranoid style in American politics, and it can be quite effective. Anyway, so you go to appeals court, you can appeal things, you end up going to federal courts, which are ultimately deriving from the Constitution, and the Supreme Court, of course, which makes decisions that are the end of the road, the final appeal, and it can only be reversed by Congress passing a law or by the Supreme Court nullifying their own law, like they recently did with Roe versus Wade. They legalized abortion, and then 50 years later, they unlegalized it again. So they can overrule themselves. And very likely, that the Democrats get in, there will be a huge push to legalize it again, which they can do in Congress. So this is the glorious American balance of powers. There are many people pushing around in different directions, yelling and screaming at each other, instead of having like a dictator that can just make rules. So, all right, there's all these appellate courts and district courts, state courts, and all that jazz. So there are probate courts that have things to do when people die, who gets the money, family courts, traffic courts, juvenile, small claims, and municipal courts handling various levels of things. And in New York, there's a bunch of different districts. You hear a lot about this because New York is really big and important. Anyway, all that is usually above your pay grade. All that I leave to the lawyers I worked with. If you're the forensic analyst, what you mostly worry about is evidence rules. So you have to understand what happens in trial. First, there's jury selection. They make these people show up for jury duty, then they pull in a lot of them, like 50. Then they go through and decide which ones of them are eligible to be the jury by asking you questions to see if you appear to be biased or something. And if you are, then the two sides can remove you, and eventually they have some surviving jurors that are chosen. Then they give them an oath and give them preliminary instructions, telling them things like you're not allowed to discuss the case outside the courtroom. Maybe you're going to be cloistered in a hotel room for the whole duration of the case. You're not supposed to read newspaper articles about it, and that sort of thing. Then both sides make opening statements declaring what they're going to prove, and then you have testimony of witness and other evidence. This is where your expert witness will speak along with other witnesses. Then closing arguments, then jury instructions, where the judge explains to them what the law is and exactly what they're supposed to determine, which is usually not obvious by common sense at all. And then they go into deliberations for as long as it takes, and then there's a verdict, and then separately, after that's over, that comes sentencing, if the person is determined to be guilty. So that's the right to a trial by jury as outlined in the Sixth Amendment, and therefore you have the right to a speedy and public trial, and you have the right to be faced by your accusers, which leads to a lot of problems in cases where the witnesses do not want to have their identity exposed or even exposed to the defendant. So sometimes they hide them behind a screen or something in mob trials and such. Voir dire is the process of selecting the jury. Like I say, both sides and the judge can ask you questions to determine if you are trustworthy. When I did this, they asked me what my profession was, and I said I'm an ethical hacker, and they all freaked out. Everybody asked me about that. The judge asked me about that. They thought I was a criminal and I should be thrown off, but they eventually decided I wasn't and let me on.
I think I found a method for being excused by the selection jury.
Yeah.
You say that you have a higher degree and you start talking a little bit sophisticated.
This is what my mother said. She said, all you have to do is tell them you have a PhD and they'll throw you off. I don't know if that's still true. But anyway, they didn't throw me off. I stayed on, and it was an interesting case. I thought it was very fair. Everybody was trying real hard to be fair. So anyway, so you might be sequestered. We're actually isolated. You can't go home. You can't talk to anybody else because the case is getting a lot of publicity, and they're afraid that you will get tainted by that. You'll get contempt of court if the judge decides to punish anybody for violating the rules of the court. And the foreperson is the juror seated. Contempt of court, by the way, is quite serious. And one of the big cases where this happens is journalists. If a journalist gains some evidence that was, for example, a secret document leaked to them, like the Pentagon Papers or the stuff that Chelsea Manning leaked, then the Now, if you're a priest and someone confesses to you, you have the right to not tell that testimony. And if you're married to somebody, you are not required to testify against your marital partner. But journalists do not enjoy any such protection. The police can come to you and demand that you hand over your source. And if you don't, you can go to prison for contempt of court. And New York Times journalists and other ones have gone to jail for a year or longer for not revealing their sources. And this is why, since WikiLeaks came out, they all wised up, and now they have special portals we've talked about before, so you can submit secret documents to the newspaper, and they really don't even know who you are. So they can't possibly be forced to hand over that information. And I think they're hoping that they can't be sent to prison for not handing over the information, since they can prove they really don't have it. I don't know if that works, but that seems like a pretty good plan. Anyway, all right. So they make the opening statements. And remember, the prosecution goes first because they have the burden of proof. You do not have to defend yourself at all. If you're accused of anything, you do not need to present any defense because you're assumed innocent until proven guilty. The prosecution must prove you're guilty. If they don't prove it, then you don't need to defend yourself. All right. So then you deliberate. You get a hung jury if the jury cannot come to a unanimous decision. And then the trial is canceled, and the prosecutor has to decide whether to bother trying you again or just let you go. All right, in criminal trials, somebody is likely to go to prison. And the one other thing about criminal trials, you do not need to have a plaintiff. For example, if you murder somebody, there may be nobody to complain about that. The person who got hurt is dead, but the state will prosecute you, saying we must prosecute this crime even though there is no particular person here complaining. The state finds this offensive and will prosecute you. All right, felonies are serious crimes with a year or more in prison. Misdemeanors are less serious.
No, because this is negative law. The civil cases are positive law. So in the sense that if we do a contract, which is civil law,
yeah,
so we
civil
state
law.
what the rules that we have to observe.
Well, yeah, the civil law,
yeah,
the state will prosecute criminal law, even if there's no one complaining.
Right.
But civil law, that won't happen.
Right,
like if we have a contract.
In cases, what is described by the law is behavior that you should not act.
Well, that's true. Yeah, but if we sign a contract and I feel that you don't live up to the contract, it doesn't go to court unless one of us decides to take it to court.
Right.
Yeah.
Right.
But anyway, so you might have to make it. By the way, this is a big deal in the Trump case, the Trump New York case. When he lied about the value of his properties to affect the insurance and loans that he got on those properties. He got money through sort of making fraudulent financial statements, but those were only misdemeanors. And there was a highly questionable process used in a New York trial to try to take like a dozen misdemeanors and turn them into a felony, which was very questionable. And I think that case has pretty much been hung up and probably going to collapse for that reason. It's very unclear that him lying on his financial disclosure to the value of his properties is really a felony in New York City. So anyway, all right. So civil trials are about money. One big issue is the standard of proof. In a civil trial, you just have to prove it to a standard of the preponderance of the evidence, which is more likely than not, like 51%. That's enough to win a civil case. But in a criminal case, you have to prove beyond a reasonable doubt because it's much more serious. It's not just that you lose money, somebody actually goes to prison, and therefore you have to have a much higher degree of punishment. And this is the decision made in America, which you could certainly argue with, and Donald Trump very much does argue with, that we would rather let a guilty man go free than jail an innocent one. And you constantly hear Trump on the stump talk about how much he likes Duterte in the Philippines because he just said, go kill the drug dealers. He said, all you gangs can just go shoot drug dealers in the street because I'm going to get rid of the drug dealers. And Trump advocates this. This is where you would much rather punish the guilty, even you don't even care if some innocent people get hurt in the way. It's another way to go. But we go the other way. It's fine if 10 guilty people go free rather than one innocent person get convicted. That's how our system is. And that's why the cops lead lives of great frustration. They catch the guy, they know he did it, but they lose in court. They let him out on the street, and the cops say, why do we bother arresting these guys when you just let them go? But that is our system. They get every chance to prove some doubt, and very often they do. So anyway, there's depositions in civil trial. You don't need to go to court. You can just make a recorded deposition that is evidence, and so on. All right. So constitutional law is based on the Constitution, typically the First Amendment, that gives you freedom of speech and supposedly separation of church and state, although that's taking a big beating these days.
Okay, so I have
Yeah.
a question.
Yeah,
Separation of the church and state.
yeah.
Why do we swear on the Bible then in court?
It's a very good question. You are, in fact, allowed to use other holy books now. You could use the Quran or even something else in principle. However, they just bought, I think, several $1 million worth of Trump Bibles in Oklahoma to go in the classrooms, which is a highly questionable move, and probably it's going to be challenged based on separation of church and state, and so you'll see what happens. So, like all these things, it's a pushing thing. They used to have prayers and the Bible and Bible lessons in school, and now they don't because of this. But the Supreme Court ruled recently that the football player at a high school that made his team form a circle and pray before the game was allowed to do that by claiming that he did it in private and only with people who wanted to do it, even though the evidence had photographs of him doing it in public and forcing all the players to do it. So the Supreme Court recently is willing to just make rulings in absolute contradictions of the facts that are plainly there. The majority of the right-wingers will just agree to something even when it's absolutely clear that it's false. This is like the ruling that you can discriminate against gay people based on the fact that a website designer claimed that a gay person might come to them and ask them to make a website, and they might disprove, but it turned out that none of this was true. The web designer had never made any websites, and the person they said asked for it was a fake person, and there was no actual injury, so there was actually no standing. So it is pretty disturbing. We're having decisions made in complete defiance of all the rules by the Supreme Court because they've been pushed very far to the right.
Was there other episode of the baker who refused
Yeah.
to
That's an old one. Yeah, that's right. There's that one. There really was a baker though, and somebody really asked for the cake. The website designer was completely fake. The person was just thinking about making website business, but they hadn't. And the actual named person that they said asked for the cake turned out to be a real person who was not gay and had never asked for this website. They just picked like a random name. It was false, and they still went through the Supreme Court. This is called a complete absence of standing. You're not allowed to go to court unless you have standing, which means somebody has to be here who has been injured. Something has to have really happened, because we're going to rule on the specifics of this case. If you just want to have a theoretical thing, like I hate trans people and we want to outlaw them, that you can do in Congress. Congress can make a rule without any exact specifics of one person that was injured, but in court you have to have a specific circumstance where something happened, and it's going to depend on the details of that. That's called standing. Anyway, so there's some cases that have to do with the internet to set these standards and such. And then there's the Fourth Amendment, which is a big deal, which means you cannot get evidence without a search warrant. Although this was greatly weakened after 9/11 with the Patriot Act, anything involving terrorism, they're pretty much allowed to ignore this rule. So you can get things, you can seize evidence without a warrant or in violation of your rights, but it will be usually inadmissible in court. There are exceptions, though, such as exigent circumstances. If it is an emergency, like there's a bomb that's going to go off or somebody has a hostage that's dying somewhere, then the cops are allowed to ignore all the rules and just go in and seize things, and that will not be inadmissible because there was a good reason you didn't go through the formal process of getting a search warrant. But if the fruit of the poisonous tree is the term for if you get some evidence through an illegal search and then you investigate and find other evidence, all that evidence is now inadmissible. It's fruit of the poisonous tree. You wouldn't have it unless you did this. Bad thing. Certiorari is an order made by a higher court that redirects it to a lower court for further review. This is what the Supreme Court often does. The Supreme Court often gets cases and they say, well, in fact, the lower court should make another look at this again. They send it back for re-review. And motion in limine is a motion to suppress evidence because you claim that one of these bad things has happened. They did it without a search warrant, they violated somebody's rights, and therefore this evidence should be removed, which of course is often extremely important. This can often end the whole trial because you get to exclude the all-important evidence, and without that, they can't prove it. So in search warrants, a big thing for forensic investigators, you have to get a search warrant. The search warrant says what you are looking for, what kind of evidence you're allowed to seize, where you're allowed to get it from. You don't just get to take everything willy-nilly. And you have to prove that you have probable cause. You have to already have evidence that there is have a cause to say, we have a reason to believe that if we search this house and look on that computer, we will find evidence of a crime. They can't just do it out of the blue. They have to convince a judge that it is probably true that a crime has been committed and that there's something in there that we will find if we search it. So warrants are specific to a particular crime and particular investigation, and typically to a geographical location. And this leads to some real problems on the internet, when they wanted to prosecute people for cryptocurrency fraud, the cryptocurrency people said, cryptocurrency doesn't live in any nation or in any town or any state, so it's outside jurisdiction of everybody. They tried to claim this, and they lost in court. The people had made some cryptocurrency fraud. They said, no, the developer who wrote the software, you can be prosecuted where they live, even though you claim the software lives in the internet. We don't care. And then there were real problems when Microsoft wanted to take down botnets. Microsoft found botnets taking over millions of Windows machines, and they wanted to run code to disconnect those machines from the botnet, which is running code on somebody else's machine without permission, and they wanted to take over the botnet command and control centers, and they somehow got court orders that made those things legal, and I don't understand how, because you don't even know that those machines are located within the jurisdiction of the court. No court actually has jurisdiction over that, but somehow Microsoft has several times managed to get court orders authorizing these activities. Other companies like Google just do it even though it's illegal. When Google got hacked by China, they hacked China back and stole all the data, and I spoke to the Secret Service agents. They visited my class, and I said, wasn't that illegal? And they said, yeah, that was illegal, and we told Google not to do it. But they did it, and nobody from China tried to press charges in American court, I guess. So the internet is kind of a wild west where people just do rotten things to each other pretty much outside the law. But there are people that try to do it within legal boundaries, like Microsoft, and somehow they're able to get orders authorizing them to take down a botnet, even though parts of that are in another nation. I do not understand how that works. Anyway, all right. And here they have an example where law enforcement got a warrant to search a house, but they put the computer in a shed in the back of the house, and that was not covered by the warrant. So you can't seize it. That's the thing, Another case that one of my trainers told me about is he got an order to seize a computer, and the lawyer said, oh, gee, I'm sorry, before you seized it, my client sold it to me, and I wiped the hard drive and reinstalled Windows, so the evidence is all gone. And he said, I want it anyway. And they said, uh-oh. And they settled. They hadn't realized that reinstalling Windows doesn't erase everything. So I'll still find plenty of evidence on it. And they said, let's just settle. Let's not go there. Anyway, then there's warrantless searches. The Patriot Act means if you have something to do with terrorism, then you don't need a search warrant. If it's foreign people, not citizens, they have no privacy at all. You can just take their stuff. You can wiretap their phone and everything in America, which is why it's illegal European law for any European company to use American services, but they all do it anyway with a thin shell of pretense that they will have some privacy here, what first called safe harbor, and now there's a new version of this. It's actually a very fragile legal structure that makes it possible for European companies to use American services, but they all do because the American services are cheaper and better. And there are a few enthusiasts like Mikko Hyponen who keep saying Europe could get together and make some open source stuff that's as good as Google and Yahoo and Microsoft and everything, but that hasn't happened. So if you want to do business in Europe, you use this thin veneer of a law that makes it technically legal to send that European data to be processed on American systems, even though they will have no privacy here. Anyway, if you agree to a search, then you don't need a search warrant. Of course, when you waive your rights, and you can also, with an emergency, you can get there. So you usually use knock and talk. To enter a home, you have to get consent of the person to enter the home, otherwise they're going to need a search warrant. And there's plain view doctrine. If something is just sitting out in plain view and they don't even need to enter your house to see it, then that can be enough. They don't need a search warrant for that, things that are just easily visible. And there are, of course, edge cases that people argue about. All right, a plain error indicates a major mistake made in court proceedings, even though no objection was made. Criminal procedure or the rules, and we talk about search incident to a lawful address. This is how you do a warrantless search after an arrest has been made. And we talked about standing. Yeah. So a lot of cases that affect these things. So digital surveillance is a big issue. Stingrays are one big issue. So if they want to spy on cell phone conversations, the way they actually do it is they drive a van into your neighborhood, they put up an antenna, and project that they are a cell phone tower. Your phone will now connect to that tower because it has higher power or it's closer. And then they use a downgrade attack to lower security of the cryptography down to an old standard like GSM2, which can be cracked. and now they can intercept your phone calls, and therefore they get not only the phone call they're authorized to get, but all the phone calls in the neighborhood.
Is this what is called wiretapping?
Yes, this is the modern version of wiretapping. In the old day, it was done with physical wires on the physically wired network. This is how you do it on the cell phone network. And it has the effect that you get a bunch of things you're not authorized to examine. You'll get all the phone calls made in the area, and then they supposedly ignore the others.
In Europe, it's done for against mobsters. There are environmental wiretapping, it's called, right?
Yeah.
More or less the
Yeah.
translation.
So they call it a stingray. Now, there's two things you can do. You can actually intercept the phone call so you can hear the speech. That's one way. But a simpler thing is a pen register, which just gets the information that would be on the phone bill, which is what phone number called what phone number at what time and for how long. That's the pen register, and you need a much lower standard of evidence. You can do that, I think, without a search warrant. And that's often all you need, because if you want to know who's in a gang, what you do is you arrest one of them, and then the other gang will call the other gang members, warning them, oh, the cops are coming, and you just watch the pen register, you find out who's in the gang. You don't really need to hear the content of the calls to get a lot of value out of the pen register.
Well, that implies that you know already something about the case. About the
Yeah, that's right. Well, yeah, you always have to know something to start from. And so you can get a court order. And a court order is a big deal. The police often come to companies and ask them things like, tell me who this Twitter person is, tell me who this voice over IP customer is. Some companies will just hand it over, like AT&T. AT&T just hands over everything because they're basically part of the government. Other companies are very vigorous, like Twitter, in refusing these, and they require a court order. It's up to the company whether they want a court order. However, if they don't require a court order, if they come to me and I just hand over your information, you can sue me. Why did you hand over my information to somebody? And I'll have to defend that, but if I had a court order, I can say, I had no choice. They forced me to do it. So, all right. And then there's GPS tracking, which is a huge issue. I mean, the cops have tried to argue, I've seen cases where they just put a GPS tracker on somebody's car, like a magnet someplace, and they say, we don't need a court order for that because it's out in plain view on the streets, and we could have just had a car following you. All this is just a way to save time and money. And they've tried to argue that, and people have argued the other way, and I don't think it's really been resolved yet. Do you need a court order to track somebody's GPS? All right. This is the question. Monitoring signals does not invade any legitimate expectation of privacy, so there's no search or seizure. That was their claim in U.S. versus not. The undercarriage is part of the car's exterior and thus is not afforded a reasonable expectation of privacy. That's the decision in these cases here, but I've heard arguments and stuff. I think this is not 100% settled yet, but there are a couple of precedents suggesting that police are allowed to do this without a warrant. And then traffic stops, of course. Do you need a warrant to search the cell phone of someone who is arrested? That's a big deal, and now they have, this case in 2014 said that they do need a warrant to search the cell phone of someone who is arrested. I've read other cases where they say they don't. Anyway, there's another issue, is even if they have the right to search your cell phone, what if it's locked? Do you have to unlock it? And the court, what I've read in many articles have said, if it's biometrics, they can force you to put your finger on it or point it at your face. But if it's a PIN or a password, they can't force you to divulge it because the First Amendment originally only gave you freedom of speech. That was the original intent. You can say whatever you want. But around 1970, there was a person being forced to recite the Pledge of Allegiance in school. And they used the First Amendment and said, you can't make me say something I don't want to say. And since then, they interpreted it to have the other meaning that you cannot be compelled to speak, which is not the original meaning of it, but the Supreme Court agreed with that. So now, the government cannot compel you to speak. You're allowed to remain silent, and therefore, if they ask you for your password, you're allowed to not give it. But if they want your fingerprint, you're not allowed to not give it, because they can already take that, or your photograph of your face. So that's why people say if you want real privacy, don't use biometrics. Use a PIN. Anyway. All right, and the Fifth Amendment protects you from self-incrimination. You're not required to testify against yourself, so you can refuse to answer questions like plead the fifth, like Donald Trump did in case. And so grand jury is a particular jury that decides whether you should be prosecuted. That's an indictment. And the Fifth Amendment can influence the outcome of the investigations. You can't force someone to supply a password because that might lead to you discovering criminal stuff on the scene, so that could be self-incrimination. But they can be forced to use your finger because that's not knowledge, that's not speech. All right. The Sixth Amendment doesn't directly affect us. It's got something to do with that you're allowed to get a trial. You're allowed to be confronted by your accusers. You can see who's accusing you. And then there's the Wiretap Act, which is a big deal. this, I think, is CALEA, or and the ECPA changed it. These are things that determine whether the telephone network, the CALEA, the Assisting Law Enforcement Act, requires everyone who provides telephone services to build systems that let the police wiretap them. So they have to have the correct wires and cables and everything, so that when they're given a court order, the police can listen in on the calls. But this does not apply to the internet. So if you use Skype or Signal to call somebody, they do not need to provide this to law enforcement, and therefore they typically build the systems where there is no way to do that. And there are many, every couple of years it comes up again, and the FBI tries to get Congress to pass a law requiring internet traffic to be subject to wiretap orders, but this has not happened yet. It has gotten close several times, but they do not have that law yet, so internet traffic does not provide wiretap capability to law enforcement in general. They are not required to, and there's no reason for the providers to do that in the absence of a law forcing them to. So here's stored communications, applying things. All right. And then there's the Foreign Intelligence Surveillance Act. These are these FISA courts, and that's why I say foreigners have no real privacy in America. Amended by the Patriot Act to include in its scope terrorism. So if they want to intercept traffic of a foreign person, they can just do it, and the foreign person is not even notified. And the Computer Fraud and Abuse Act is the act that is usually used to punish hackers. People who hack into a system and do something are typically punished under this. It is an old law, and what it says is if you connect to a computer used on the internet, technically, they originally said a computer used for interstate commerce, because this was the early days before the internet. And now every computer is connected to interstate systems, every web service, so it applies to every computer, which was not the original intention. And if you connect to such a computer and you gain information that you are not authorized to have, you've broken this law. And this means, in principle, if you go to a website, right-click and view source and find a vulnerability, you have now broken the law. Because the point is, it says anything you're not authorized to have, and that means whatever the owner of that computer feels like you should do. It doesn't even have to be written terms of acceptable use. If you just do something that they feel exceeds what you are allowed to do, then you can be accused of breaking this law. But then your defense attorney can try to say this was legitimate use, what you did. And I've come across this many times. Every security researcher does. If you look for vulnerabilities on the internet, you're very likely taking some risk of breaking this law. You find a vulnerability on a website, that's not what they intended for you to know. You have now gained information that you're not really authorized to have, even if you didn't have to hack through a password or anything to get there. This is frequently misunderstood. And then there's corporate espionage. If you steal data for corporate secrets, this is a big type of hacking that's done, and type of espionage. There are spies from companies that spy on other companies and spy on unions and such. All right, there's a lot of other issues here. There's CALEA, that's what I mentioned. This is the wing that forces telephone providers to let law enforcement agents wiretap phone calls. And they must build equipment for that and plan for it when given a correct wiretap order. And then the Patriot Act after 9/11, if you look at Europe, in Britain, there's almost no privacy because they had a lot of terrorism, so the people are very, very afraid, so they mostly agree that the cops can read my email and anything to stop all the terrorism because of the Irish Republican Army. They had a lot of bombs going off, and so people were afraid, and they said, I don't need privacy, I need protection from this terrorism, and that was the feeling in America after 9/11. So they gave almost unlimited rights to inspect anything without a warrant in the pursuit of terrorism, because people were very, very afraid.
I think on the other side of the spectrum there is Germany.
Oh,
Germany, because of the war,
because they've had a fascist government, they're very worried. That's right.
So it's so difficult to get authorization. Even for social science data, if you want to have data at the neighborhood level, you cannot. County level or large.
Yeah. Yeah, and this is what happens. You move wherever your society wants to move. It depends on what you're worried about. And for a while, we were very, very worried about terrorism, obviously. Now less so, and people are beginning to push back for more privacy. If there's another terrorist act, then they'll move back that way. All right. And then, of course, exploiting children. This is a big idea. Before 9/11, the number one FBI priority was what they call innocent images, child porn. And now it's number two, terrorism first and then child porn. At least it was when I looked at it a few years ago. But those are really, really the most highest priority crimes in America. These are the things that people get really, really, really mad about, is exploiting children. So This is why teaching forensics used to be really nasty, because forensics used to be pretty much all about child porn, an unpleasant topic to talk about. Now it's mostly about terrorism, but anyway, so, all right. And then there's the Digital Millennium Copyright Act that made it possible to do commerce over the internet, so you could view a signature, a digital signature, and now you could get a bank loan or a mortgage or a business transaction over the internet. Before this, you pretty much had to have a real piece of paper signed with a pen to do anything financial. You couldn't really transact business over the internet. And so evidence admissibility, there's the Fry test determining that evidence must be, expert opinion must be derived from a thing and must be based on science that is demonstrable and not experimental. And therefore, lie detectors are not evidence in court because they're not considered reliable. Fiber evidence, like threads they find in a car seat, were used for decades, but about a year ago they declared that they're no longer admissible. They decided they're too unreliable. And things like fingerprints have been reliable for a long time. These things come and go. As the science changes and opinions about the science changes, they determine what science is really generally agreed to be accurate enough for this purpose and what isn't. And there are many very scandalous cases of forensic examiners that falsified evidence for decades and sent hundreds of people to jail by lying about the evidence. This happened many times, and that's there's a lot of dirt in the business. Then there's the Daubert tools. This talks about how forensic examiners must perform benchmark testing on their tools, showing that they're working. And the federal rules of evidence deal with expert testimony. So if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence, a witness qualified as an expert may testify thereto, and this is the heart of what I've been saying. The expert witness is the only person who is allowed to state an opinion, and that opinion becomes evidence. Everybody else's opinion is meaningless. All that matters is what you saw, direct evidence, but the expert is allowed to have an opinion, and that opinion is evidence to the extent that they're convinced that the expert has sufficient expertise. And that's why you have to prove that you have experience, training, or education to mean that you should be trusted, and your opinion should be considered to prove something. So that's what the forensic examiner is, an expert witness. It's not firsthand, and you're allowed to provide your opinion during a trial. And both defense and prosecution can have their own expert witnesses who argue about this and decide. They can cross-examine the other experts. So this guy can say, no, you're wrong. You misinterpreted the evidence. You used the wrong tool, that sort of thing. You're allowed to have that argument. And so it will depend on how much you can convince people that you did it right and humiliate the other expert and show that they don't know anything, which I've been told is pretty easy to do. I haven't testified in trial, but my trainers have. And they say if you just obey the simple rules, you will almost always find that the other person didn't. Because most forensic examiners, at least a few years ago, he said, were pretty incompetent. He said the typical forensic examiner on the other side is a law enforcement agent that has been to a 3-hour vendor training course. So all they know is click on this, click on that, take the output, and if you ask them, where is that on the disk, how is that stored, how is that encrypted, they have no idea. So you can pretty easily show that you know more than them. So, all right. Expert witness must provide a written report. That's part of discovery, where you provide the disclosure of an expert witness, and you typically have a report with a complete statement of all the opinions you will express and the basis and reasons for them, the facts used to form these opinions, exhibits that will support them, which will be the output of your forensic tool, listing of files and binary outputs and images and stuff you found, your qualifications, the other cases you've been on, and a statement of how much money you were paid. All these things are part of your report. They can weigh all that. They can decide, this guy's getting paid a lot, he's probably lying, or something like that. Okay, and then you must provide the name of each witness. This has been a huge issue in the Trump trials. It is very clear that anybody who testifies against Trump will be completely harassed by Trump supporters, typically driven out of their town, fired from their job, and everything else. So in several of Trump's cases, the witnesses have been concealed. And they have, in other cases, they were exposed by judges who are more sympathetic to Trump. It's been a huge issue. It's also a huge issue in mob trials, which are pretty much the same thing, where it's dangerous to testify, and so you try to get an exception made to this rule. All right. Identification of each document and exhibit and all that, then the federal rules of evidence and hearsay. So you can use memorandum report records or data compilation in any form of things. This is how you can use automatically generated things like server logs, which might not be considered evidence because they're not something a human created or a human saw, but they are automatically created by the machine, and they're allowed in here under federal rules of evidence.
How did you call it? Silver box?
What's that?
How
Oh, server logs, and also email, spreadsheet, system logs. These are things that are stored in a computer, and there is not a human who made them necessarily, so they might not be evidence, but this is how you determine that things created in the normal course of business are admissible as evidence that something happened. Otherwise, it would be very hard to prosecute computer crimes, because most of the evidence is automatically created by the computer. And that evidence is not hearsay. So best evidence is the original evidence. This is why you never examine the original machine. You find a machine, and all you do is you image it. You copy the hard drive, you copy the RAM, then you lock that machine up in the safe, and you study only a copy, because you have to have best evidence. It means you have to go to court and say, this whomp is the computer that was used to commit the crime, not a copy of it, the thing. Just like you bring in the gun. This was the actual thing used in the crime. That is best evidence. A copy of it is not best evidence. It may have some value, but it's not as good as best evidence. The original thing that was used in the crime is what you want. All right, and so everybody gets the right to defense counsel, of course. And there's the California Consumer Privacy Act is an imitation of the European GDPR in California only, and it's very new, and there's only been a couple of attempts to actually punish people under it, and I think it is still very unclear exactly how it works and exactly what it means. There's an attempt to be pretty much like the European privacy law, but how will that work in America, I think, is still being determined. In the European Union, of course, they got a lot of other laws, and data privacy is the big one, GDPR. This is the big one. They gave people in Europe a lot of privacy about their data. The biggest thing I know about this is in Europe, if you gather private information about anybody, their name, address, phone number, anything, you have to tell them why you're gathering it, and then you have to only use it for that purpose. And if you want to use it for some other purpose, you have to go to them and get permission again. In America, that is not true. You can collect data and then resell it to someone else who would do something different with it. And that's why we have these data brokers that just know everything about everybody, just selling it all over the place, like the one that just lost all their data last month. So all of our data is just out there now. This won't happen in Europe because of GDPR. But it did happen here, and there's still no law against it in America. So that's an issue here. They also make distinction between personal and sensitive data. This is personal information that can identify you, like your email address or IP address. Sensitive is things like race, ethnicity, political opinions, and so on that might get you in trouble. And this reminds me of when the 23andMe got hacked, and they dumped out all the genetic data. The hackers stole it, tried to sell it for like $4 million, and nobody would buy it. So he made a subset of the data that listed all the Jews. And he thought people would pay for that. Anti-Semites who wanted to find and punish the Jews. I don't think anybody bought it, but it does point out how scary this is. That's why I always recommend to all my friends, don't use these genetic testing services. You don't want your DNA in some public database, because the government may decide to go after you and your kind, and a permanent record of your ethnic makeup is not going to be used for any good purpose, I think. Anyway, all right, there's more details about the GDPR. With limits on data connection and retention, you may have limited access to things. It may have quite a lot of effect on cases in Europe, but no direct effect in America. All right. And so you may have, in all these cases, of course, you may have to have an attorney. Whenever you're working on anything legal, you have to have an attorney advising you what you can do, what you can't do. It takes an expert to know what you're allowed to do. China has the greatest restriction on internet content, and the government monitors everything with the Great Firewall of China, of course. And India is becoming quite similar. They're restricting things a lot under Modi. But they don't have a Great Firewall of India yet. They were going to put one in Australia. About 10 years ago, the president or prime minister, whoever's in charge of Australia, declared that he was going to put a firewall on Australia that would block all pornography, all viruses, and all illegal content, like stolen MP3s. And all the technical people said, you can't do that. There's nothing you can buy that will do that. And he said, we're going to do it. And he spent millions of dollars and years trying to do it and eventually failed. The fact is, there's nothing you can buy that will do that. There's a lot of people that would like that, but there is no box you can buy that will do that. Anyway, all right, so let's take a look at a Kahoot. Here we go. probably have to move this over so you can see the number. There. Okay, good. Oh, I believe that's true. I think if you throw it out, then anybody can take it. I think the garbage company can argue with it, but yeah, I think you don't have any more privacy after you throw something out. I believe that's true, but I'm not sure. I know people do this. They go through like used machines they buy and find stuff, and then some people have argued whether you really have a legal right to that.
According to what we said earlier, what we saw up in this class,
Yeah.
I'm arguing with myself and say, okay, but how about if I put everything in the garbage bin? The garbage bin is mine, you know? Who's ecology?
Yeah, I've heard arguments that after you put it in the bin, it's actually in possession of the garbage company, or maybe the city that hired the garbage company. I don't know the answer, but I have seen some arguments. And I've also heard people say, I bought a used laptop and I found all these pictures. Can I just put them on the internet? And they say, maybe not. Maybe that's harassing the original owner. You don't really have the right to do anything you want with them. And I don't know how this came out. I don't think it's 100% clear. Like if you were to find like evidence of a crime or naked pictures, then publishing them might still be an act of harassment. Even though you sort of technically own them, the guy could argue that you didn't need to go exposing them like that. So I think this is why you need lawyers, and specific. This is why you can't go to court with a theoretical argument. You have to go to with a real case, because it will always get down to the exact details of this case. What did you do? When did you do it? How did it affect this person? It's not a general rule. It's a specific case. They have to be able to investigate real crime to make a verdict. You can't just be something you made up.
It makes sense with the logic that then you create a precedent.
Yeah. But then you can argue whether that precedent applies, because the precedent will be for that case under those circumstances, and the next case is not really exactly the same. So you argue it doesn't apply because in my case, different things happened. And that's why, that's why we Americans spend so much time in court. You can argue every little detail, and therefore we have a lot of rights. They really have to have a lot of evidence against you, and you get a lot of chances to save yourself before you get locked up. All right. All right, so what kind of law is made by state legislatures? That's statutory law, like the abortion bans in all the states. All right. Somebody says this lecture against him thinking of My Cousin Vinny. I think that's a movie. I don't know it, but there's a million cop cases on movies and TV shows about this that teach us a lot about this. Police procedurals and court procedurals are a big genre of fiction because it's very interesting. It's the modern equivalent of the old shootouts. Anyway, so when you ask jurors questions to see if they're biased, what's that? That's voir voir jury, which is Latin. It means to see and to say, I think. And that's the point. You talk to them and see what they say, and from that you try to decide whether this person is really going to fairly judge the case or whether they appear to be biased.
No, really, I think it's French. What is it?
It could be, but I think it's actually Latin, and the French probably got it from Latin. Almost all this stuff is Latin because this all goes back to Rome. Yeah, all these legal principles have been around since Rome, pretty much. Yeah, yeah. All right. So, what request does a lawyer make to suppress evidence? Motion in limine, declaring that for some reason this evidence should be inadmissible. All right, what device records phone numbers? That's the pen register. Now the Stingray does get numbers, but it also gets the full content of the call. And that you require a special wiretap order for, but the pen register you don't. That's where you just get the phone numbers that were called and when they were called. So that's the most direct answer to the question. All right. All right, so a hacker intrudes onto a network, so what law have they broken? Yeah, typically it's the CFAA. I'm thinking if it would be better if I said they went onto a server here. That would make it 100% clear. But I don't think it's wiretap. That's telephone calls. So the CFAA is typically what you get prosecuted under. Although, if all you did was compromise the network, for example, just taking over the router, I wonder, you might not be violating the CFAA because you didn't get on a computer. You only got on the network. Now, there's another law called electronic communications law, ECPA. That's probably the one you'd be violating if all you did was take over the router. But I'm not sure. Anyway. All right. My grader reminded me it's appropriate to tell you, if you use a fake name, you've got to tell us who you really are or you won't get your points. Okay, so I'm going to stop this recording.